I'm attorney Ryan Pacyga, and today I'm going to talk about misdemeanor assault. And first thing I want to clear up is there's domestic assault, which is a separate form of crime, and I'll talk about that in another video that you can find on my channel, which you're welcome to subscribe to if you haven't. But for now, I'm going to talk about regular fifth-degree assault in Minnesota in particular. And there are two forms of that. The statute that you might look up if you've been charged with a crime is 609.224. But then there are two subdivisions. Subdivision 1, parenthesis 1, is causing an act with intent to cause fear in someone else of immediate bodily harm or death. And that's what this video is going to be about. The other video will be about intentionally inflicting or attempting to inflict bodily harm. So in other words, there are two ways that you can be charged with misdemeanor assault in Minnesota. Either intending to cause fear in someone else of immediate bodily harm or death, or actually inflicting bodily harm or death. Right now I'm just going to talk about the fear statute. So if you're looking on your ticket, which is a citation, it would say 609.224 subdivision 1, parenthesis 1, or it just might say misdemeanor assault fear is what that would say. And what the law says is that you're guilty of a misdemeanor if you intentionally commit an act with intent to cause fear in someone else of immediate bodily harm or death. That starts out as a misdemeanor, which means the maximum punishment is 90 days in jail and a $1,000 fine. It doesn't necessarily mean that you'll do 90 days in jail or have a $1,000 fine, but those are the maximums, and in some circumstances that could happen. These crimes are what are called enhanceable, which means if you have a prior assault conviction or a prior domestic assault conviction and you are charged with a new misdemeanor assault against either the same victim within a 10-year period or a previously qualified domestic, you can be charged with then a gross misdemeanor violation of this. Basically, like DWIs get more serious if you've had a prior, some assaults can get more serious if you've had prior assault convictions. In addition to that, you ought to know that there could be other consequences like firearms situations. If the judge determines that a firearm was used, even if you didn't shoot the firearm, but that if you own a firearm and that a firearm was used, you could lose that firearm as well. And sometimes you can also be a subject of further criminal penalties for that as well. So that's something else to watch for. I think for most people, if you haven't, what are you going to be worried about here, or what should you be worried about? There's a couple things. More often than not, you're not facing a lot of jail as a consequence. You may certainly be facing 2 years of probation, maybe if the alcohol was involved, not being able to drink while you're on release on your case, and maybe for the whole 2 years of probation, or some other things. But I think for the everyday person, the biggest concern is what this can do to your future plans. It can sometimes cause you to lose a job if you have an assault conviction. It certainly can prohibit you or make it harder for you to get another job, either if you want to make a move to another company. You see an advertising thing or a headhunter contacts you and they talk about a position to recruit you for another company, and all of a sudden you go to an interview and you do well and they say you're hired pending a background check. That happens a lot. And then they do this background check, and if you have an assault conviction on your record, you're more than likely either A, not eligible because of that company's own human resources rules about who they can and can't hire, or B, they just decide, you're so close to another candidate, one candidate doesn't have an assault conviction and you do, and more often you get passed over for that, because they're worried about, well, what if you ever reoffended in the workplace or something, and that opens up the company to a lawsuit because they had prior knowledge of you having an assault conviction, which might be unfair to treat you that way, but employers can and will do that in situations. So I think the biggest collateral consequence that you might not be thinking about in your determining whether to go defend yourself or have a lawyer is, what's it going to cost you in the long run? You may save a little bit of money up front trying to do it on your own, but if you don't get the result where that domestic assault or that assault charge is dismissed, you then may very well find out that it's much more expensive later because you've lost opportunities either to rise up within the company you're already in and get promoted, or to make a move over to another company where you've got some higher income potential. That could cost you tens of thousands or potentially hundreds of thousands of dollars over the course of your lifetime in lost earnings. Another thing, parents, whether you're married or not, if you have a child and you want to volunteer for their activities down the road, either as a coach for youth sports or of other activities like the Boys or Girl Scouts or things like that, or schools are always sending out notices asking parents to help volunteer to read for a class or do recess duty or 3 chaperones for a field trip or something like that. Yeah, they have to do a background check, and a lot of times you won't be able to do that, and that's going to affect how you want to be there for your children and participate in their activities. Or if you're married and later on there's a divorce, and all of a sudden there's an argument about how much parenting time you get or not. Sometimes those arguments are made against you as well. So I think generally for someone else who doesn't have a prior criminal record and you're facing this, you want to watch out not only for, geez, could I go to jail, or what would probation look like, but what's this going to do to opportunities for me in the future? And that's what I think is really important, that I want to tell my clients, and things that we seek to protect, because you want to keep as many opportunities open for yourself in the future, both from an employment and just a volunteer standpoint. And so be aware of that if you're charged with a misdemeanor assault. There are many defenses to these things, including but not limited to involuntary intoxication, self-defense, or flat out, I didn't do this, they're accusing me of this, but I never did this, or my intent wasn't to cause them fear of bodily harm or death. And so there are several defenses. Those are some of the most common, and a good lawyer that knows how to defend these knows when to bring these up for you and to take that home either to the prosecutor and seek to have that charge dismissed or lowered, or to a jury if they won't listen to it. We'll get in front of a jury and present that for you as well. So if you have any questions about misdemeanor assault in Minnesota, you can call me at 612-339-5844 or come to my website, www.arrestedmn.com. Thanks.